Event started at 10 a.m. And earlier in the day, we had a session where we are analyzing the NICN's adoption of international best practices. And it was indeed an interactive session with questions and answers. This afternoon session promises to be even more exciting as we get to officially host the first presidential debate. I think Ellan deserves a round of applause. Thank you very much. Now, this is the second edition of the presidential debate put together by Ellan. And Ellan is, of course, the Employment and Labor Lawyers Association of Nigeria. Today, we get to meet our presidential candidates or aspirants, and we will ask them the questions that have been tugging at our hearts, the questions that lots of us have been wanting to know about, because at the end of the day, the NBA is ours. My name is Olive Emodi. I'm a lawyer and a TV host, and once again, honored to serve as your compare. Now, today's event, we will be affording you the opportunity to ask questions right after the debate has happened. So you ask what Ellan stands to push, what Ellan is trying to push in the body, amongst the body of lawyers. But before I get started, I'd like to specially recognize everyone here, but to say thank you to our presidential aspirant, us today. We say thank you very much. And unfortunately, we would like to apologize because due to circumstances beyond our control, Mr. Yakubu Chonoko Mekiao, SAN, will not be joining us for the debate. But of course, we will proceed with the debate as planned. I'd like to especially recognize the presence of Mr. Emeka Ngige, SAN. Thank you so much, Leonard Silk, for joining us. Cut the first session, Mr. Afolabi Kuti, SAN. I don't know if Leonard Silk is with us, but it's understandable if he isn't with us because he's done a phenomenal job anchoring the first session. In fact, I had said to him, SAN, please don't anchor next time, not because you're not good, but because I don't want you to take my work from me because he did such a great job. So can we please put our hands together for him in absentia? All right, now it's time for us to get to officially meet our presidential aspirants, and I will
Sorry for that. I was looking for our ground rules, yes. So I'm going to set some ground rules before we start for this interactive session. We have 8 minutes to answer each question. Nominees or surrogates will not be allowed to participate in the interrogative session in place of candidates. No placards, posters, stickers, or such other campaign materials may be displayed by candidates, by anybody during the interactive session. Then the interactive session will also include questions, primarily from me and then the participating audience at the end of the day. There are limits on statements, answers, rebuttals, and responses will be enforced by the moderator during the interactive session. I also reserve the right to interrupt any candidate if I believe that the candidate is straying away from the topic, right? Gentlemen, are we agreed? The candidates may not interrupt one another. It's only the moderator who can do so at her discretion. Candidates may write notes if they want, if they choose, and candidates will remain in their designated position during the interactive session. So let's begin. I'm going to start with a question on capacity building, and I want us to understand that these are questions that have been collated from members of the legal profession. We took time out to do a survey to ask people to send in questions, and these are popular questions that have come as feedback from members. These are things that agitate the minds of a lot of people, and we want to hear your responses. So be as short and as quick as possible. It's not a lot of time, 8 minutes, and we're already behind schedule. So if I see that you're straying from the topic, I will cut you off. Thank you, gentlemen. So I'm going to start with you, Chief J.K. Gadzama, SAN, and the question is on capacity building. What plans do you have for Nigerian lawyers to improve their capacity and to build on the foundation of continuous legal education of the current administration? Do you understand the question, sir? What plans do you have for Nigerian lawyers to improve their capacity and to build on the foundation of continuous legal education of the current administration? 8 minutes.
Yes. Thank you, Shola, for the question, and permit me to appreciate Ellan for this wonderful opportunity to talk about profession, the issues we are facing as a body, and for us to give some answers to some of the interrogations and questions. If you look at the Nigerian Bar Association Constitution to 2021, one of the major objectives and aims as enshrined therein is to provide and ensure legal education, continuing legal education, professional development, advocacy, and jurisprudence. The Olumide Akwata administration has done very, very well in the last 2 years. And the cornerstone, the foundation of my manifesto as a candidate for the office of the president of the MBA is based on continuity, innovation, and creativity. I will ensure that lawyers are trained and retrained in terms of their chosen areas of law practice. And I say so because this is something that one has been doing over time. It is often said that the day you stop learning, you begin to die. And by way of imposition of this task on oneself over time since one became a lawyer or a senior lawyer, this is something one has been doing in office, ensuring that many lawyers are encouraged to do so. So we will ensure that the Continuing Legal Education Committee of the Nigerian Bar Association at the federal level and also across the branches, we have 125 branches nationwide, keep up doing this training for our members, and we make sure that the speakers are drawn from different jurisdictions within the country, outside the country, more so that these days with online participation, the costs are reduced and the opportunity is there for one to join and participate at all times. And another thing is that the Nigerian Bar Association will, under my leadership, by the grace of God, if I become the president of NBA, introduce with the approval of NEC and of course the leadership of the bar after sufficient consultation, a kind of licensing program so that lawyers will begin to earn points if they attend conferences, workshops, symposia, seminars within the country and outside, especially for some categories, particularly where you find the young lawyers, because they need to be well mentored, they need to be carried along, they need to be introduced to a lot of things that will give them sufficient guidance professionally, which has not been the case. You will agree with me that there used to be pupillage in this country for young lawyers in the past. I've been a lawyer for over 30 years. I never met pupillage in this country, and pupillage is the last stage a law graduate goes through before one begins to practice law. It has ceased to be compulsory in Nigeria, but in England, for example, where I practice also as a lawyer at Lincoln's Inn, I remember in 2008 when I was admitted to practice law, I had to do the compulsory pupillage, but a reduced one, 2 months practicing and 2 months non-practicing. So we have reached a stage in our professional life as an association, as a profession, to decide for ourselves why we are not having that. But the consensus that we need to bring that back for our young ones so that they can become better editions and versions of ourselves with the senior ones. Mentorship, of course, through that, one can as well ensure that the young ones get the requisite experience, training, and exposure that they need to grow in the profession. So, like I said earlier, one of the main objectives in the Constitution is to push to the front burner continuous education and skills acquisition for lawyers so that that will impact positively on service delivery to our clients, to the Nigerian population, and generally to the society, so that as lawyers we can be good ambassadors of the profession and represent the profession appropriately. And that will not be limited to only the lawyers, but that will include also judicial officers, because it takes two to tango. The lawyers need that, and in the same vein, judicial officers across board, from the Supreme Court down the ladder. A lot has been done, but we need to do more, because the greatest room on this planet's Earth is the room for improvement. Whatever you are doing, you need to improve upon that. So I encourage that. I do that in my office. I've done that for myself, going around the world and schooling and educating myself. And we have a lot of resources in this country, teachers all over. We have them at the Nigerian Institute of Advanced Legal Studies. We have them in various faculties. And then we have them also in private practice. And we'll make sure that everyone is carried on board so that we can together move the profession in terms of acquisition of more and more knowledge, education, and expanding the cost of our knowledge as lawyers. Thank you very much.
Thank you, Leonard Silk.
Hello, Chief. Hello, Chief.
Thank you very much, Oli. Thank you, Leonard Silk. So I listened to you intently and I was happy to hear you talk about pupillage because that takes me to my very next question. Most of the best lawyers that we have in the country today credit their success to strong pupillage and mentoring that they received from senior lawyers. With the increasing number of lawyers being churned out from our law schools, how do we reimagine mentoring in today's legal profession, mentoring of the young ones? And what programs do you have to support the senior lawyers to develop capacity and to assist them in their mentoring obligations to the younger ones? Mr. Tidy, I would like you to take this question.
Thank you very much for the platform.
Hello, Chief. Hello, Chief.
Mentoring, as it were, is not backed by any law at the moment in our legal system. I recall sometime in 1984, there was a decree that sought to regulate pupillage. However, when the Legal Practitioners Act was brought into being, came into being, whether deliberately or otherwise, there was no specific mention of compulsory pupillage. So what you have to entitle you to practice law in our jurisdiction is that you're called to bar, you've been found fit and proper, and so and off you go. There's no such requirement that you will have undergone some form of pupillage. Now, what we have in practice is a sort of pupillage while undergoing training, where as a law student, as an aspirant to the bar, you undertake court attachment as well as the law office attachment. And so once you're unleashed on society, there is no regulatory regime that makes it compulsory for you to learn, understudy, or be a pupil under a senior colleague who would put you through the ropes. By the grace of God, under my administration, one of the very key aspects of pupillage that we're going to take on board would be to make it compulsory, but remunerated. And you ask me, how do we bring it in and make it a compulsion? We have to go back to the Legal Practitioners Act. Good enough. It's undergoing some panel beating now, so the formal bill will be presented to the National Assembly for amendment. And that is the point at which we can bring this in to say, in order to avert the kind of calamity that will befall us when we witness dwindling standards, we have to be a sort of, we have to be proactive to say standards are falling today, and we cannot afford to continue to look at ourselves like this, that once you're called to bar, you're unleashed on the market, there is no regulatory regime. What it does is that it leaves the new lawyer to his fate. And so is the survival of the fittest, which is not in itself good for our kind of country. The opportunities are limited, and so we must try to perfect our skills in the chosen areas of endeavor, so that if you want to be a courtroom lawyer, you're well equipped to be able to undertake those tasks. Now, how do we ensure that they are remunerated? Because if you make it compulsory, how do you get the lawyer to undergo that with the rising cost of living and all that? That is where the need for remuneration comes in. It must be, even in England, where we're told on good authority that it is remunerated. So here we look at the economic realities and have a standard basic minimum that every entrant will be entitled to save for a period of XYZ years, 3 years, 4 years, 5 years, so that within that period, your pay will not only take you home, but it will also put some things on your table, so that you'll be able to surmount the exigencies of society, because the legal profession is a noble profession. So we cannot afford to have our colleagues who will look like charge and bail. So it must be an all-encompassing regime of deliberately introducing pupillage in our laws and then making it very, very attractive to our new wigs as they come into the profession. Now, you have to also take this further. How do we deal with some of our colleagues that are already there in the market and we have to move from point A to point B, and at times they're unable to deliver on the tasks that they have before them? This is where you bring in the ICLE. They need to continuously train our members deliberately too, because we cannot afford to remain stuck with what we were taught several years ago. We must update at all times, because society itself is dynamic, is changing, and so we cannot afford to live with an archaic training. So for those of us that are already in legal practice, there also be the need to continuously turn out that aspect of pupillage, which is the ICLE, which will be made compulsory as well, so that you earn points for each training that you have participated in. So these are going to be deliberate policies. It's going to be an administration that will deliberately go to where the issues are and deal with the issues there. The issues won't come to us and then we'll be lost if we keep waiting for the issues to come and meet us where we are. They will talk about them forever without dealing with the issues. So we're going to be going deliberately to the issues to deal with them one after the other.
Thank you very much. So, because thank you, because we're very particular about this question, and that's why I allowed you to talk for all of 8 minutes. So, as the moderator, I'm going to amend the rules. Now we're going to talk for 5 minutes on this next question, and because I want to take as many questions as possible, and I know that members of the audience also have questions, and we're going to get a lot more from people who have joined online. And so we want to get, the benefit of your insights on a lot of issues. So, but we'll still try and finish on time, 4 o'clock. So, but let's take as many questions as we can. I'm going to move to rule of law issues, and I'm glad that it was Mr. Tidy, and you also alluded to it, Leonard Silk, when you said that standards have fallen. And so let's talk about standards and the rule of law. What programs, if any, do you have towards strengthening the rule of law enforcement, and reforms in Nigeria during your tenure?
Well, Shola, thank you for asking me a question on an area that I'm very passionate about: rule of law, law enforcement, and so on and so forth. Rule of law, of course, it's the most important fundamental for a democratic setting like ours, which we claim to practice in this country. Because rule of law provides the oxygen to make our democracy work. But again, for rule of law to thrive, there are some requirements, certain factors that must be in place to make sure that rule of law works and we all have the benefits of rule of law in our country. In the first place, there must be good laws. Secondly, there must be strong institutions. And thirdly, there must be due process in whatever we do as a body or even as a nation. Now, for I remember as far back as probably 20 years ago, when bar leaders gathered in Abuja, and I remember very well at the Hilton, I was there in person. We changed the mantra, the catchphrase of the Nigerian Bar Association from ubi jus ibi remedium to promoting the rule of law because of its importance, so that it can remain in the sight of everyone that this is what we are looking for. Now, to have rule of law apply to everyone, we must remember that there should be no sacred cow among us, and that no one is exempted if we want a society that can progress and develop, and we want to have a secured environment for everyone. Now, we must look at ourselves as leaders in this country by dint of being members of the noble profession. We must make sure that uh, the relevant organs, the stakeholders, are not complacent. Now, when you talk of stakeholders in the sustenance, application, and promotion of rule of law, enforcement of law, you are talking about, for example, the judiciary. You are talking about the police. You are talking about even the prison or correctional centers, as the case may be. You are talking about so many other agencies. And when we talk about judiciary, of course, we are talking about all cadres, all levels of courts. And then you are talking about stakeholders, the public as well, the lawyers, we that constitute the membership of the Nigerian Bar Association, which is a critical stakeholder, a pressure group, and of course, the first among equals in terms of bodies that can ensure that government and those in power, and indeed everyone, complies and promotes rule of law. Because we are at a crossroads in this country. While we are looking inwardly as an association to take care of our welfare, our security, and economic advancement among lawyers, we must remember that Nigeria is at a crossroads. We must talk truth to power. We must ensure that we perform our critical role of being watchdogs of the society, and ensure that those in power are subjected to rule of law. So it's so important, and we have to sit up. Thank you very much.
Thank you very much. Right on time. I like the notes that you ended on. It's so important. And I'm going to pose the same question to Mr. Tidy. Rule of law is so important. What programs, if any, do you have on this issue?
Let me begin on the note that administration of justice is very critical to the rule of law. And today, our administration of justice regime is not only very slow, but frustratingly so. And there is no way we can continue to shout the rule of law when we don't deal with the issues that are a clog in our path towards attaining rule of law. One of it is, do our citizens have access to justice? You will answer that question whichever way you want. The truth of the matter is that the response mechanism, the access to justice mechanism in our country leaves so much more to be desired. So we must deal with the issues that constitute a big clog in our attaining what we want to call the rule of law. The primary objective of the Nigerian Bar Association, and that is our motto, is promoting the rule of law. So what is the rule of law itself? It is that whatever we do is governed by law, and we act according to law. Now, there are instances where you have gone to court, obtained judgment, and it becomes a bigger problem to execute or enforce that judgment. Now, what is the satisfaction? Haven't gone to court, spent 10 years, and now you start a new journey of how to enforce that judgment. Now, remember, some of our colleagues are one way or the other involved in the process. For instance, where you have judgment against a government agency or parastatal or ministry, there is always a lawyer on the other side who, rather than advise his employers or the ministry or parastatal that he works for to say, look, let's obey this judgment, he looks for excuses to say, no, we can find a way around it. Go and apply for Attorney General's consent and so on and so forth. So rather than being a solution provider, we find some of our colleagues that are in there constituting a very big log on our, in our journey towards attaining the rule of law. So unless we deal radically with those issues, we continue to shout and yearn for rule of law. Meanwhile, what we have would be rule of men or rule by men, which, God forbid, will never allow you to get to the aim of having society which is attainment of justice. So unless we build very strong institutions that can work, whether or not there are individuals manning them, they will be further away from attaining the rule of law. So radically, the bar must take the lead in terms of advocating for improved access to justice, whether the clerks in the administration of justice who must deal with them, delay in our proceedings who must deal with it headlong. What is the attitude of our colleagues who, when they know they do not have a very good case, they want to file multiple applications to frustrate hearing of matters? We must deal with those problems, and so on and so forth. By and large, we must all come together under the umbrella of the Nigerian Bar Association and reach an agreement that we need to move away from where we are now, a scenario where we lose a lot of income. The litigating public is losing interest by the day in the legal profession because of the sort of slow pace of attaining justice, and so on and so forth. But when we are resolved to get it right, you'll be amazed at the sort of income that our colleagues will again begin to earn. To also bring respect to legal practitioners again, to restore our respect, and society will be better for it. Those in government today who feel that they are almighty will begin to have a rethink, because they will now see that the lawyers are resolved, moving in one direction, that we all must obey and do things according to law, and not necessarily the way the man that is there thinks he wants to get away with what he's doing. So the Bar Association must be at the forefront under the leadership of the president, by the grace of God, have the capacity to fix those very multiple problems that we have around militating against our quick dispensation of justice. Thank you.
Time off. Thank you. Right on time too. I hope we're noting our questions so that we can put them to the candidates afterwards. I'm going to stick with you, Mr. Tidy, and come to this question that also has to do, that I also want to get your thoughts on how we can raise our capacity in that area. In recent times, we've had a lot of cases of sexual harassment. In fact, if you follow the trend online, there's been the Me Too trend. There was even a trend recently, the toxic workplaces and toxic bosses trend that was online recently. And I was shocked that some young lawyers came out to talk about their principals, harassing them sexually. And we continue to hear increasing cases of sexual harassment, even in our law firms. So I want to get your comments on this. I don't know if you're aware of the trend, if you know that it is an issue, how much of an issue you think it is, and what you will do about it if you become president.
Now, the issue of the issue of sexual harassment is a big problem that we have, and it is with us in the legal profession. Now, I won't talk about the various forms of sexual harassment that we have, but then we have to find a common ground. How do we deal with the very recurring problem of sexual harassment? Before I get to the other part of how we deal with those who have made it their uniform to intimidate and harass our colleagues, our female colleagues, let us even try to start from what is responsible for what I call the inability of our colleagues to be able to hold their shoulders high. There is a lot of discrimination in our climb, whether we like it or not. And that discriminatory practice exposes some of our female colleagues to no choice but to look up to having to fit in somewhere because the opportunities are limited extremely. And so you find some of our colleagues that have no choice, nowhere to go, but to come before the senior colleague who has worn the uniform of a predator, who is looking at the female younger colleague as a prey rather than as a colleague that should be mentored. Now, we must deliberately equip our female colleagues. In fact, if I have my way, they need much more attention and equipment than our male colleagues, because our male colleagues can withstand quite a lot of pressure. But here we have our male colleagues that need some kind of special care. So we must give them that environment that entitles them to compete favorably for whatever opportunities that are available. If you're able to do that, there are most of them that will be able to walk away when the man begins to look at them beyond the ordinary. They walk away and tell you, look, sorry, my time is up. I need to get out of here. So that you don't place them and they're fixed permanently there. They don't have a choice, nowhere else to go to. Now, but beyond that, we must deal with the problem of those that engage in whatever form of sexual harassment. Under my watch, I'll propose, I'll be very radical about this. After all, it does not require proof beyond reasonable doubt like you have in our criminal trials where the slightest iota of doubt will get the man go scot-free. This is going to be by affidavit evidence, LPDC. We're going to make it very, very functional so that the day you make one example of our colleague who descends so low as to try to take undue advantage of our female colleagues, others who nurse or who are dreaming of similar tendencies will sit up. They will take their eyes away from where they're not supposed to look and treat our female colleagues with respect. Now, so if you deal with the problem headlong, LPDC must be activated and expeditiously. You don't waste so much time with this kind of matter, so that make 1, 2, 3 examples, and I can assure you the scenario will put itself in order. So we're going to be very deliberate about this as well.
Thank you. Good to hear. Leonard Silk, the NBA I know has come up with a sexual harassment policy. Do you think that they've done enough, or what else could have been done to deal with this issue? What would you do differently? How would you handle issues like this when they come up?
Thank you, Shola, on this question that uh, raises a lot of concern, not just among us as lawyers in Nigeria, but it's a major concern the world over, even at the IBA level. I remember in 2018, the International Bar Association came out and came up with a policy on on the sex harassment and gender balancing or imbalancing among lawyers in the profession. And to a large extent, sometime in 2021 in Port Harcourt during the AGC, we as a profession, we as a bar, also came up with ours, which is essentially the same with that of the IBA. In terms of policy, the MBA has done well on that. What now remains is implementation. But it is something that leaves a sour taste in the mouth because statistics tell us that out of every 3 female lawyers, one is sexually harassed. While on the other hand, out of 15 male lawyers, only one is harassed sexually. Now, I think we have to encourage our colleagues, especially the younger ones, to expose those who make efforts or attempt to harass them sexually. They must be given that protection, and as much as possible, try to come up with evidence of such insolence on the part of colleagues who, because of their exalted positions in various offices, they use that to threaten and intimidate and subjugate the younger ones into such kind of illicit behavior because of the disadvantaged situations they happen to find themselves. So, what does that mean? That means we must come out with stiff penalties, including disbarment of any lawyer found to have engaged in that, because it tarnishes the reputation of the profession, which we believe is the first among equals among all professions. So if lawyers can harass themselves sexually in a workplace, in other words, you can only promote a colleague if you exploit a colleague sexually, or you can only employ a colleague into your workplace if such a person succumbs to your sexual threats, intimidation, and desires. I think we need to do something about that. We need to make examples with the culprits, and I support the proposed punishment to the guilty ones. We must make sure that that is unheard of among ourselves in our workplaces, whether in the private sector or in the public sector. This is my take on that. Thank you very much.
Thank you, Leonard Silk. I'm glad that we all agree that we need to raise the standards where it concerns sexual harassment. I'm going to stick with you, Leonard Silk. Still talking about the female gender and issues that affect them, we often say that the law profession, that in the profession, the preponderance of opinion is that female lawyers are underrepresented, and a lot of them are looking away from the profession. And there is a growing trend that a lot of them are looking towards other career paths. What plans do you have to ensure diversity in the profession and keep female lawyers in the profession?
Well, I think I will start by uttering this wise saying that charity begins at home, although it doesn't end there. What do I mean by saying that? Take myself as a case study or as an example. Of all the lawyers we have in our office, 65% population are female lawyers. In other words, they have female lawyers in our office have more than that, the 35% affirmative action, which they are entitled to. In fact, that has doubled it. So, and oftentimes we find that many of these women, female lawyers, are talented. Many of them do better than even we, the men. I will give you an example. The immediate past managing partner in my law firm, Keradimba, is a woman. She's not here with us because she's now in Canada advancing her studies. And there's a possibility she will come back and continue to render the good services and work she was doing while she was with us. We've learned a lot from her. So, I mean, why can't we give women that opportunity to compete favorably, right, with the men? We have to implement this policy, and we should not be considering any primordial factor of difference in sex or gender. What matters is ability of someone to provide legal services unhindered by gender chauvinism. So I want to say that women in our group, I mean, among us as lawyers, should be encouraged. And FIDA, there must be collaboration with FIDA, as well as the Women's Forum of the NBA. If they face any challenge, they should say so. And we, the leaders of the bar, must make sure that they are carried along and these issues are addressed squarely because we need them. There can be no society without a woman. There can be no family without a woman. The woman's role is critical, and oftentimes the foundation, the backbone of a family, of a man, is woman. So how can you exist without women around you? Someone, I mean, so you must create. I'm not saying that women should be treated as sacred cows, but at the same time, oftentimes because of the psychological belief that they are women, you see, they need that support from men. And what I always say this: once there's an issue to be resolved between a man and a woman, and it's on the borderline. I mean, equal equities. If you look at the equities and they're equal, my resolution personally is to favor the woman. So this is how I resolve it often, more often than not. But the long and short of it is that we must encourage our female colleagues because they do well, even as judges, even as practicing lawyers. Yeah, we have many of them who wear silk, and they compete favorably with the women, with the men folk. And we have many women, female lawyers who do well in commercial practice, commercial law practice, fintech, tech law, etc., etc. So we appreciate them, and I stand for them, and they must be counted. Thank you.
Thank you very much, Leonard Silk. Mr. Tidy, I'll bring the question to you too. Leonard Silk personalized it when he told us about his firm and what obtains. So what obtains in your firm? Are the women in the majority too? And how will you keep more female lawyers in the profession and ensure diversity?
Okay, let me start from my practical experience. As of today, I have no male junior in my office. All the lawyers I have there are female, and and this dates back to as far back as 2006 when we engaged the first set of female lawyers, and they kept coming back. I remember on one occasion, one of them had a birthday, and she had work to do. And my attitude to our female colleagues, with all due respect, is I put you in the position of a male colleague, so they're able to function maximally with little or no supervision. And so the party was set, but then the conflicting role, I have to get these papers ready so that tomorrow they're filed and all that. And I recall she had difficulty passing that message across. But of course, what I'm trying to say is that we must give them that level playing field. First of all, that our female colleagues have the confidence to be where our male colleagues are, or even beyond where our male colleagues are. That way, the tendency to want to go and be a cashier or a teller in the bank as a trained lawyer, the tendency will be less. Because for me, I do not look forward to see our colleagues after undergoing training, and we prefer now to take to other businesses like hairdressing. Yes, you can own those businesses if the law allows, but not as a matter of first choice. So let us bring back our female colleagues to the profession so that they can showcase the talents that they do have. And we must do this too deliberately. If you have committees, for example, in the NBA, and you're going to give one male position in the committee, I advocate that for every one man, you have two women in the committee. You're going to have diversity in terms of trying to engage even in those assignments, because women are much more in depth. They're a lot more patient in trying to analyze the issues and all that. So we must encourage them deliberately to take the front seat and not run away from what we are doing as men, and so on and so forth.
Thank you. Thank you very much. I'm going to stick with issues of harassment, but harassment of a different kind. Issues of harassment of lawyers by security agents in the course of their duties. I mean, we've heard of lawyers being assaulted and battered, and it's just so sad to hear of such stories. But we say that the profession is a noble one, but to hear of lawyers being beaten, assaulted, detained, I mean, I'm sure you've also heard of this. I mean, it's common. What are your plans to curb this and ensure that a lawyer can perform his duties without fear of intimidation or harassment?
Well, Shola, you asked a question that relates to a topic or an area that is so dear to me. Um, so dear to me because Mr. Olumide Apata, some 6 months ago, saw the need to have what is now referred to as Nigerian Bar Association Security Agencies Relations Committee, which was approved at NEC meeting in Abeokuta, I think on the 16th of December 2021. Now, I am now the pioneer chairman of that very important committee, which is an ad hoc committee, but we are praying that sooner than later it will become a standing committee because of its critical importance. Now, why that committee? That is the question. The answer is not far to fetch because of recent, or rather, particularly sometime last year, you will find that there were so many reported cases of harassment, intimidation, molestation, arrest, detention, unnecessarily for that matter, of lawyers, men of nobility and dignity. And when you investigate most of these cases, you'll find that there was no necessity for such misbehavior or act of misbehavior by the security agencies, which, I mean, about 2 dozens in number. But the one that comes closest, the one that comes more in contact with the lawyers, of course, the police, because they're everywhere. We have police formations, stations all over the country. And lawyers, especially the young ones, go to the police station on behalf of the clients, to request for the enforcement and compliance with fundamental rules, procedures, and what have you. Why are you keeping this man unnecessary? Why can't you release him on administrative bail and things like that? More often than not, the lawyer who is the hunter becomes the hunted. The lawyers might be arrested, and of recent, this our committee has been able to intervene in over 15 cases within the span of just 3 months from when we were inaugurated, and lawyers were released. We were able to get public apology from the police and other security agencies. We were able to recover about 10 million for someone, and were able to make sure that the number of such cases has drastically reduced. I think you must have heard of an alleged situation of a magistrate in Mushin, but I swung into action immediately, but we later discovered that it was not as black as it was painted. There was an altercation between the magistrate and the police officers at the police station in Mushin, but she wasn't arrested, the magistrate wasn't detained, and so on and so forth. That was how we kept our gunpowder dry. But all I will tell you, as a result of my appointment and service now as the pioneer chairman, and as a result of the fact that as far back as 2006 also, when Olisa Abakoba was the SAN was the president of MBA, I was appointed as the pioneer chairman of MBA SPDL, which is the section on public interest and development law that serves as the ligament between the society on the one hand and the legal profession. So because of these two appointments, not because my father was a policeman, not because I grew up in the police barrack, right? But simply because of these two appointments and the experience, and then the fact that one has courage, one calls a spade, one is fearless, one has all the wherewithal to tell those in power politely that what you are doing is wrong. And then there are many ways out in terms of going to court, making public statements, and condemning some of those things, and then collaborating with our colleagues who are lawyers in most of these agencies to ensure that the right thing is done and lawyers are treated with respect, right? So the situation has improved. We are praying that it will sustain that. So we have a program of action, and we are now developing terms of engagement with all the agencies. Even if a lawyer is wrong in doing something, there are ways to you can invite the lawyer. If he refuses to come, you can send a letter to or talk to the chairman or a bar leader. So lawyers must be treated with respect because they are the bastion of the common man. They are the hope of the common man. And if the lawyer is facing incarceration and threat and what have you, then what is the situation of the common man? So this is my take on that. Thank you very much.
Thank you very much, Leonard Silk. Mr. Tidy, I'd like to hear your thoughts about this issue too. Is the SARC, the committee that Leonard Silk has told us about, are they doing enough? What would you do differently?
Um, I won't say the committee is not doing enough, but we need to go beyond what the committee is doing in tackling the issue of harassment by security agents. Let us understand first of all what is giving rise to harassment. I take the case of a lawyer who has been briefed by a client to protect his right. On the other hand, you have a policeman who, probably because of lack of training, feels that he must get out a confessional statement from the client, even if it means the worst form of torture. So, see, this, rather than complement the roles that we play in the administration of justice, on the other hand, the police or the security agent misunderstands the role they're expected to play. ACJA has provisions on how witness statements should be obtained. But they won't want to hear any of that because the lawyer is there to remind them that, look, let's go by the prescription of law to insist that there is recorded. Meanwhile, they want it outside so that they can do their job the way they think they should do it. So one of the things that we will do differently would be that we must take that leadership and make an example of one of those security agents that are found to have harassed or beaten up our colleague. From start to finish, you must follow up to make sure that proper investigation is carried out, prosecuted, and if convicted, serves the sentence. I bet you others who have the penchant to unleash their weapons on our colleagues, we think twice before they do it, irrespective of whichever security agents they belong. It doesn't matter whether it's the police or the army. We must have that very right. Make good example of one of them, and I'm sure the rest will have a rethink. Secondly, the NBA has the vital role to fix whatever crack there is in society. It's a misnomer that you have government officials that do not understand their role in society. And so it's also the duty of the NBA to play a very active role. What role do you play in this circumstance? We have donor agencies that are ready to provide funding for training so that we can advocate for training of these security agents to be able to know their role as security agents and how to perform them. So we're helping to society by ensuring that those people know how to, in a civil way, carry out the tasks that they're supposed to carry out. Most of them had that archaic training of the old. They haven't been retrained. And so they have that mindset. So we'll be doing good to society to also advocate that they're retrained at all times so that we have that simultaneous approach. The other part of it is to, at the NBA, keep a register of those who are found culpable so that we can display it from time to time and know our security agents who are not deserving of any seat in any public place because of the kind of mindset they have. So we must do this frontally, and I can assure you, it will become a thing of the past. It will be drastically reduced to the barest minimum.
Thank you very much, Lynette Senior. So let's change gear, and I want to talk about the issue of alternative dispute resolution and the award of SAN. A lot of people are bothered, I don't know if you are, that despite the broad consensus that ADR is fundamental to the speedy resolution of disputes, it counts for little in the consideration of award for the rank of silk. What are your thoughts on this?
Well, thank you, Shola. Well, probably starting point will be to recall that, yes, I wear silk by God's grace. Recall also that I'm an arbitrator and a chartered arbitrator and a member of the Chartered History Arbitrators UK, and I've been the chairman in Abuja for the entire North in the past. And then I'm also a member of the Nigerian Institute of Chartered Arbitrators. Now, but that is not the point. The point is this: despite the fact that I did not rely on any award or any arbitral proceeding as a condition or a requirement to wear silk, that does not mean I should not be supportive of those who deserve to wear silk, who have met such conditions, if they are. And they are, and they should be. Because what matters is ability to perform the functions or the duties of a senior advocate of Nigeria. And again, the advantage of awarding the rank of senior advocate of Nigeria to arbitrators who are found worthy, right, capable, and intelligent enough to wear silk is that by so doing, you are promoting speedy and fast dispensation of justice and hearing and determination of disputes before in the justice administrations in Nigeria, in the system. So I vote for that those who are able to have awards, I mean, whether you win or not is not the issue, just like judgments of court. But if you perform in an arbitration that a lot of hard work is demonstrated and is very visible, that should count. I support it. And there are many arbitrators who are silk, and they are equal to the task. And I remember the effort we made in opening the doors to have as many colleagues wear silk as possible. Because in the past, like when I was made a silk, we were 12 in number. But these days, you have over 70. There is a call from some quarters that why should the number be that big? It should be reduced. But what matters is ability to meet the requirements, not the number. If 2 meet the requirements, give the 2 applicants a silk. If 100 meet the requirement, give them. That is the position in England. That's the position in England. This is what I stand for. I've issued a statement on this as far back as 2010 in writing. And it has come to pass, and this is what is being practiced now. The fact that I became SAN and we're 12 in number does not mean others should not become. Right? So once you meet the requirements, and there's no any criminal conviction against you, and there's no any established ethical misconduct against you. In other words, the LPDC has not found you guilty or responsible for a particular act of misconduct. You should, once you meet the requirement, because if it is not like that, and you change the rules of the game when you want to award, a lot of people will now look at it that other primordial factors coming in, nepotism, corruption, and what have you. And let me tell you, in England, applicants are taught how to apply. you participate, you pay a token, you come and sit before a group of people that will teach you what to do, how to apply, and you become. Then again, if by adventure you are not made an SAN, you will be told why you didn't make it, and you will be persuaded and convinced as to why you didn't make it. So the entire system should be made more transparent, right? And it will work for all. This is my contribution on that. Thank you.
But let me, thank you. But let me just quickly ask a follow-up question. Like, what specific steps would you take to ensure that those who meet the criteria through the ADR are qualified and enrolled as allowed to take silk?
Well, specific steps will include, but not limited, for example, um, you have to consider the panelists. Who are the panelists in terms of panel of arbitrators? Probably who, I mean, in terms of what is their discipline, because there's no requirement of the law that a panelist or an arbitrator must be a lawyer. It could be a surveyor. The person could be anybody. All over the world, anybody can be an arbitrator, even if you don't have the certificated qualifications as an arbitrator. Once the parties want you to mediate or arbitrate among the disputants, so be it. So there may be consideration as to who the panelists were, what were the issues that were discussed. Were there strong issues, or were they just mere issues? And then you must not limited your inquiry, right, to just the award, in this case, like the judgment, but you must look at also the entirety of the proceedings, the documents that were filed before the arbitrary tribunal, and in more often than not, these awards are being challenged by way of application to the court to set aside on grounds of misconduct, which is very nebulous and generic, not necessarily the misconduct as we understand in simple terms. So, and you see that there will be pronouncement by the High Court or Federal High Court, as the case may be, and then the Court of Appeal, and probably the Supreme Court. Although we don't encourage disputants and lawyers to linger on with litigation once there's an arbitral award. But I want to say that it is as good as a judgment of court, but we have to collectively agree on what the parameters will be, what the standards should be, what minimum points requirements must be met in terms of some of these arbitral proceedings. Thank you very much.
Thank you very much. Leonard Senior, I'll bring the question to you, Mr. Tidy. Is it time for us to also fashion out, I don't know, maybe a process by which those ADR specialists can also take silk? If Leonard Silk has told us that, you know, you have to look at the issues involved, you have to look at the panel. You could be an arbitrator or an ADR specialist without necessarily being a lawyer. So is it time to have something in place which we use as a checklist for what qualifies for a person from that field to become, to take the award of SAN or something? What are your thoughts?
First of all, the rank of senior advocate is conferred by the Privileges Committee. So let us agree that it is a privilege. And the committee has set criteria. What are those A, B, C, D, the checklist that you need to meet to be able to apply, to be eligible to apply and get conferred? Let us not forget that the Bar Association has representatives on the Privileges Committee. So it is for the NBA president to push through the representative of the bar for inclusion in the checklist. Those who meet particular qualification, it could be in arbitration, just like you have our colleagues in the academia. You put in the criteria to say, in addition to the foregoing, this is an additional requirement, and those who meet it So long as you're a senior, you're a legal practitioner. So it does not admit of non-legal practitioners to be conferred. So if a surveyor is an arbitrator, he's out of it. So we need to just beef up the checklist that we have before the privileges committee, so that it can be inclusive to our members that are into arbitration and other forms of alternative dispute resolution, so that they're not excluded from this prestigious rank. Because of the inefficiencies in the normal courtroom litigation, this has become a new way of resolving disputes. So our colleagues who have veered into that area and are making handsome money also want to wear the title of senior advocate, which we believe money cannot buy. So it's only when you meet the requirements. So I agree that the bar can take a stand and say, include in the checklist those who meet this extra ABC and confer on them. I also advocate very seriously that for all those that qualify, that meet the criteria, you confer on them. If there are 8,000, confer on them. After all, how many senior advocates do we have in the whole country as of today? So we need more. So if that is one way of making sure that clients pay more, let us have more so that we get our clients to pay more money to lawyers. This money is not going to be paid to outsiders. After all, it's going to be paid into our professional colleagues' account. So for me, one of the ways you can get more money from society is to have more senior advocates conferred, so that if the minimum consultation fee is 10 million naira, you can imagine how rich lawyers will be, and will take over the whole space. And that's the way to go. So the more, for me, the merrier.
Thank you. Let's go on to issues of rules of professional conduct. I know there was a time that we all woke up to see that the rules had been amended, and I know that a case is still in court at the moment on that issue. But do you think that the RPC should be amended or remodeled to fit into current realities? If yes, how do you intend to do this? Let's start with Mr. Tidy.
This recurring problem of rules of professional conduct, let me start by answering the question. Yes, there's a need to amend the rules to reflect the current realities of practice. I give you the reason why. As General Secretary, if you receive 10 mails per day, there's a tendency that 7 or 8 of those mails are complaints against our colleagues. And so they come in their numbers on a daily basis, complaints. I'm not saying the complaints are meritorious, but we need to find a way of dealing with those complaints in a very speedy manner. When I resumed office in 2018, August, the last day of August, I met well over 4,000 active petitions, some at the LPDC, while others were still at the stage of trying to put together the documents to forward to LPDC. Now, you receive phone calls from complainants who probably complained in 2016, and 2018, that petition is still awaiting a date at the LPDC. So it gives the impression that the discipline of lawyers is not being, no priority attention is being accorded to discipline of our members. Now, what it does is a lot of damage to the profession, because litigants or those who had cause to write those petitions live with an impression that the lawyers are not trustworthy people, because that's the reason why they're writing those petitions. But if we find a way of dealing with them in a very timely manner, such that those of our members who are wrongly accused know in good time that, look, this petition has been dismissed, they move on with their lives. But the situation where you have a petition pending for 3, 4, 5 years, for me, is akin to when you have cases taking forever in our courts. To worsen matters, towards the end of our tenure, my Lord, the Chief Justice of Nigeria, made new rules. And the new rules, rather than solve the problems of speedy disposal of these petitions, has worsened it. Because in the new rules, what they try to do is the members of the LPDC will receive the petitions directly, investigate, prefer charge, and try the legal practitioner. Of course, they're going to run into the problem of all the other pattern or nebo judex in causa sua, because you cannot be a judge in your own cause. You can't be the investigator, the prosecutor, the judge, all in one. Before now, NBA used to play that role of sifting through those petitions to know those that had prima facie case. But the thinking by my lord the CJN or the Board of Benchers was that the NBA was either very too slow or trying to shield some of the members that are influential. So we need to have very straightforward rules that we allow and give timelines so that no petition comes and is taking 4 months and has not been dealt with. Let NBA continue to play the active role of sifting through those petitions so that those who want to witch hunt our members, we also have a duty to protect them. I try to advocate at some point that when you have petitioners who, because they don't want to pay their professional fees to their lawyers, who has won the case for them, and they try to say it's time to pay, no, I don't want to pay the lawyers. They say, no, we didn't have any agreement as to professional fees. So they write a petition to try to dissuade the lawyer from asking for his legitimate entitlement. We also need to take it to the level where we now seek protection for our members, which may include imposing fines on those petitions when they're found to be frivolous. So there is the overall need to amend our rules to suit the realities of today so that we can speedily revamp the image of the profession.
You. The next look. Yes. What areas of our rules
Yes.
should we
Well,
be amending?
thank you, Shola. You see, my take will be as follows. Generally speaking, the time it takes to amend any promulgated law is about 10 years on the average. Now, as far as the rules of professional conduct are concerned, haven't been passed or made or issued in 2007. We're not even in 2017. We're in 2022. Having been just rules, it is even easier and more convenient to amend because they are not law. I mean, strict sensu, like an act or a law passed by a National Assembly or House of Assembly, respectively. You talked about the purported, or let me not say purported, the amendment, so to say, by the Honorable Attorney General, which is being challenged. So, all I will say about that, it is the General Counsel of the Bar that is expected to promulgate it or to amend it or to replace it, right, with new set of rules. But having said that, I used to be a member of the General Council, but I cannot remember if meetings were called. That was even before Malemi became AG or AGF. So that's just by the way on that. Now, I subscribe to the popular view that the rules should be amended with immediate effect. Now, there are many challenges posed by those rules. But again, I will single only one because of paucity of time. And that one is this one. I know of a few lawyers that have been found guilty or irresponsible by the LPDC because they sold land or pieces of land. Because the interpretation of the rules and the traditions, the ethics so far is that lawyers should not engage themselves in the sale or purchase of land as a business. And we are the same people thinking of how do we empower ourselves. You allow others to sell land. Now, all that a lawyer is expected or allowed under ethics, under our ethos, under the traditions, as interpreted by people or by us, is that the lawyer can only prepare agreements relating to land and get peanuts, or probably 50,000, 100,000, 200,000, whatever you. While the person who sells land can get probably 10%, 5%, 20% of the cost of the land, right? So there is a debate on that, a very serious one for that matter, and it can go either way. I want us to make it a burning issue, and then, so that we can resolve on it one way or the other. But personally, I think we need to create avenues for lawyers to empower themselves. Because if you look at objectives and aims as contained in section 3, subsections 11, 12, and 13 of the NBA Constitution 2021, we have a duty as the leadership of the NBA to create wealth, to empower people. Well, of course, within the boundaries, within the parameters of the law. So we really have to look into that. And this is just one out of 1,001 instances where I think the rules should be amended. So I support, I subscribe, I throw my weight behind the proposal to amend the rules of conduct.
Professional conduct. Thank you, Leonard Silk. One more question from me, and then we'll take it to the floor. Yes, so I've been told to announce that those of you who have questions online, those watching online, and even in the room, can write their questions down. Please, if you have questions online, please post it as well so that we can ask it from the candidates here. So please get your questions ready. We'll come to you shortly. Just one last question from me, and then you'll have the floor. Only if you get ready to. Final question from me is this for now. What will you do to ensure that lawyers continue to see the bar, the NBA, as their association to belong to? Mr. Titan. Specifics now.
Yes. I recall a few years ago, not many of our colleagues were really interested in being called members of the bar association because they didn't even feel what the association was doing for them. Under the leadership of Olumide Akpata, the story seems to have changed positively because you have a very huge number of our colleagues now that are active members of the bar. So one of the things to do is to actually to sustain what it is that members are benefiting and strengthen those things that you need to do to further rekindle their interest in the association. If a member who has never had any single benefit back from the NBA now receives free stamps, packets of stamps upon payment of bar practice fees, if possible, increase the number of the packets that the lawyer gets. If a lawyer benefits from insurance claims, 1 million naira or 2 million naira as the case is now, maximize it for the lawyer. So take it to 3 million naira next time so that they're more interested and they're getting maximum value for being members of the association. So I believe if we, and then when there is any form of harassment of our colleague, let it be an injury to one, is an injury to all, and then we all in unison come together and condemn those acts and go beyond condemnation and take action so that we become again a very strong force. We're leaders in this society, so we cannot take the back seat. So I'm a proud member of the Bar Association. I believe every lawyer should feel as such, that you can walk anywhere. Let them say lawyers are arrogant. Yes, anybody who wants to be arrogant should also go and become a legal practitioner, member of the NBA. So we need to do those things that will up the interest of our members, will sustain it, improve on it at all times, dream it every time. How do we get this story more in the hearts of our members? It should be a daily thing so that we keep improving on where we are. And quite a lot today that are not interested in serving the NBA as officers. We begin to come and play active roles over here because the Bar Association needs all of you to come showcase your talent for the 2-year period, and then you can go back. This is only possible when we're able to benefit and take ownership of our association, and proudly so. So we must continue to enhance the benefits that are accruable to our members This should be our daily duty. Keep improving on it until we get to the rooftop.
Thank you. I think that deserves a round of applause. Thank you. Leonard Silk, let's hear your views on this issue.
Yeah. Thank you, Shola. Um, I want to say that I will look at it from three angles. But before I say that, I want to say that my vision, my mission, and my program of action for the Nigerian Bar Association as its president, if elected on the 16th of July, 2022. One, to look at the association inwardly and ensure that members, especially those who are financially up to date and pay their fees as and when due, are entitled to all the benefits. And many are not even aware of these benefits. And that is why a lot of lawyers don't even pay because they believe they are not enjoying the goodwill of the MBA. We are talking of stamp and seal. Yes, Olumide Apata has done well. You get 2 free packs. But again, let us work on efficiency in terms of supplying those free packs to lawyers. And then efficiency in terms of ability to get extra if you need it in a jiffy from time of application. Now, access to finance, which was just introduced, and it's a very good development, healthy one, the MBA, is about to be implemented. About 2 million for young lawyers. For at single-digit interest, we can get the interest probably lower as time goes on. We can get the amount higher as time goes on. Who tells you, who tells me that the senior lawyer does not need finance? Maybe at my level, 2 million may be too small. I may need 10 million. I may need 20. I may need 50. Let's continue that conversation so that senior lawyers, whom we must artificially and consciously assist in wealth generation for the chamber, because if they don't raise the money, they will not be able to pay the young ones. Right? What about so many other benefits? There are a lot of benefits we get, but we seem to forget. You become a notary public only if you pay your fees, practicing fees. You wear silk only if you pay, right? You sign documents, you do a lot of things, and there is even the life insurance for up to 2 million naira. There is also insurance when you are involved in a permanent disability, right? And so on and so forth. So there are a lot of benefits, but we need sensitization and enlightenment of our lawyers, our colleagues, so that they can all come and pay the expected practicing fee so that the association will be richer and richer in the interest of all. That's one. Now, the second leg of it is this. MBA leadership should look at the profession generally. Well, we've talked about the SAN application and conformment. Now, there are many other things that pose challenges to the association. And we really have to come together to look inwardly and see what we can do to overcome those challenges. But because of paucity of time, I will go to the third angle. And I look at MBA as primus inter pares among all professions in this country, right? That has the unique advantage of ensuring the right type of leadership that we expect or we're entitled to from the political class. Now, like I said earlier, we are at a crossroads in this country. And some are even opining that Nigeria is already becoming a failed state. The question is, which group of professionals can come to the aid of this country and reverse and make a U-turn of this ugly trend? It is the lawyers. Because we can ensure that there is good governance, there is transparency, and there is accountability among I mean, within the political class. And I've said time with that number that MBA is the passion of the common man. MBA is the hope of the common man. MBA is the watchdog of the society. We must be on our prowl at all times, looking for where government is doing the wrong thing, where those in authority are doing the wrong thing, so that we can call them to order. And I've said, as members of the bar, each lawyer, an average lawyer in this country, is the five senses of the visible body of the common one. Five senses in the sense that the lawyer is the eye, the nose, the mouth, the eardrum, and the receptor of the common man. Because all the senses, which involve sense of sight, sense of smell, sense of taste, sense of touch, right, and hearing, right, constitute the roles that we perform as lawyers. So we must be in the lead because of our unique advantage position as lawyers. If we don't do it, no one else will do that. And we have the capacity to do that. And where Nigerians are expecting a lot from lawyers, and we find it difficult to give that kind of leadership with courage, leadership with fearlessness, I think this country is in for that. I pray that such a situation will not come up one day whereby lawyers will be held responsible for not ensuring that the political class is getting it right in terms of leadership, so that Nigeria can continue to remain as indivisible and indissoluble as we expect it to be. Thank you very much.
Thank you very much. We join you in making that prayer to Leonard Silk. Thank you so much. Please give him another round of applause. And please give our two aspirants another round of applause. Thank you so much. I think they've done very well. We'll take you to the floor now, right?
Okay, we have questions. Please make it direct question to whom you want the question directed to. As quick as possible, state your name and your question before
Good evening, all. Yeah, my name is Nonso Azi, and my question is directed to the two contestants. Let me stand on the existing protocol, as Nigerians will say. A lot has been said about bringing back the honor and integrity of lawyers, that law is a noble profession and lawyers should be respected and be protected against police and other law enforcement harassment. Lawyers should be paid well and what have you. But I want to particularly ask this question: what are your plans to ensure that this very profession we are trying to protect, that the lawyers themselves and those who are aspiring to become lawyers carry themselves with integrity and dignity? Over time, there is no gainsaying that a lot of lawyers have lost that sense of pride and that commitment to ethics and integrity. As a lawyer, I've had complaints from clients who feel that lawyers who they hired and paid to handle their cases have done less than they should do to protect their rights. And we don't have a history of lawyers being held responsible for professional misconduct, particularly as it relates to handling cases and relating with clients or other lawyers in integrity. There is a big question hanging on our neck as lawyers or on our head regarding integrity. So I feel that it is a case of cause and effect. Granted that policemen and other law enforcement agencies and the general public no longer have that awe and respect that they have for lawyers, I think there is a corresponding reason in that The legal profession should look back inwards and say, have we been able to live up to expectations that the society requires of us? Is the standard going higher, with the advantage of technology, or is it dropping? Then, secondly, I also want you to address this issue of elevation to senior advocate of Nigeria. Well, it's a question. I asked them how they intend to address this issue of falling standard in the character, integrity, composure, and courage of life. Maybe I should just leave it there so that I don't ask so much. What do you intend to do to ensure that while we are fighting against disrespect to lawyers, that lawyers are encouraged and there is a standard that lawyers should, uphold in the society, so that that respect that we are seeking will come naturally to us, so that we don't force people to respect us. Thank you. Both contestants. Thank you very much.
Thank you very much. So we'd like to please urge our aspirants to please answer the questions as quickly as possible. We have a minute each for each aspirant.
Yeah, thank you very much for the twin questions. The first one, I had said earlier on that there's a need for us to rejig the disciplinary mechanism. But very important, it's good to be on the toes of the body of benchers to ensure that our members live up to their duties as lawyers. Otherwise, they have the responsibility of withdrawing that call to bar certificate which they gave you. We haven't seen so many examples of certificates that have been recalled. But if you have certificates recalled for such behavior that lawyers are not diligent in doing their job, I bet you a lot of us will sit up and ask questions again whether we have done the right thing that we were supposed to do. So it's a matter of attitude, because there is no punishment meted out to anybody, and so we take it for granted. So let's come back again and uphold our duties and be more thorough in what we're doing to bring all of us back to the path of honor and respect. The second one, you were talking about how we can maintain the standards of senior advocates, if I do understand you. If I have my way, when you applied to be a senior advocate, you had 5 lawyers in your law firm. Each one of them on record, you pay them 100,000 naira minimum. What happens when you're conferred with the rank? You reduce the number to 1 lawyer. So NBA should have a mechanism of oversighting. Are we really living up to the kind of things that we claimed we're living up to? So that the day the man does not keep the 5 lawyers anymore, you take back the rank and give to others who are willing to come and take 5 lawyers and pay them according to how they ought to have taken. So NBA must be alive to play that role, to ensure that our members don't cut corners, especially when they have that high elevation, to get away with the kind of requirements that come with that office.
Thank you very much, Leonard Senior. Can we please?
Thank you, Mr. Nonso Azi, if I get you right. Good, thank you. Although you appear to have asked 2 questions, I want to take them as one because both of them have the same foundation of issue of integrity, ethics, etc., etc. Now, I've said it time without number, and I want to repeat it here, and with emphasis, that the starting point to inculcate ethics, right, in us should be at the various faculties of law, not at the Nigerian law school, which is the case today. Because at the Nigerian law school, you spend just 9 months, and 9 months, probably fewer number of months intensively there, because you have to go for court attachment, you go for what have you, chambers attachment, and so on and so forth. So RPC, of course, what I often say is this: to the Christian, that is the Bible or the hymn book, and to the Muslim, the Quran. You cannot see a successful lawyer who stands tall without any indictment, who doesn't know very well. Two things I want to say here. Who does not know the ethics and does not comply with them. For you to stand tall, you must know the ethics and you comply with the ethics. How do you get the ethics at your fingertips? Catch them young. From the various faculties when they are interested in becoming lawyers and they are law students, teach a little bit of it. Because that is what you will be applying throughout your law career or practice as a lawyer. Ethical issues. You need to know the do's and the don'ts. You need to know the etiquette. You need to know the traditions. And when you just come and these days that more often than not, you find that we're in a hurry to make money. We're in a hurry to drive G-Wagon. We're in a hurry to have a big mansion. And we don't take our time, right, and grow gradually. We don't look for reputation. We don't look for knowledge. And money will come gradually in abundance. So if you make the priorities wrong or you have wrong priorities, these issues are always there. So, and secondly, we must punish ourselves, our members, the bad eggs. The legal profession, you can look at it as a microcosm of the entire society. Who man the legal profession? It is the human Nigerians, right? The same people everywhere. So if one has a particular trait in him and is a lawyer, it will show. The profession will not teach you bad things. It must be somebody's attitude or character that is the problem, not the profession teaching you how to outsmart others. So there must be, we must be checking ourselves. In fact, let me even say this, and I said it recently at a function, that if you look at Rule 55.1 and 55.2 of the RPC, it says that any lawyer who is aware that another lawyer breaches any of the rules is committing an act of professional misconduct if he does not report it to the appropriate authorities. How many lawyers have reported other lawyers that have committed acts of professional misconduct? I haven't done it. You haven't done it. So everyone is guilty. It is when we now start all over and begin to do the right thing, then there can be succor. And then we will now come back on the right track and be seen to be men of proven integrity. Because talk is cheap, but at the same time, for us to have the kind of lawyers that will represent us as our ambassadors and do the right thing. Because as a lawyer, you are a leader by virtue of being a member of the profession. Anywhere you find yourself, you are a leader in the house, in the market, in the office, among your friends. So my take is that we need to go back to the drawing board and give leadership by example to the younger ones. Then together we can demonstrate good ethical conduct and etiquette that is expected or expected from us as colleagues and a lawyer. Thank you very much.
Thank you very much, SAN. Now, we would like to crave the indulgence of everyone who has questions, so please make it as quick as possible because we're trying to wrap up by 5 p.m. and we want to take as many questions as we can, especially from those here as well as those on YouTube. So our next question will be from Chief Emeka Ngige, SAN. Leonard, Silk, over to you.
Thank you. I hope I can be seated. I want to ask this question to the candidates because any of you by August will be sworn in as president of NBA. Now we have this problem that is hot now on the plate. A letter said to have been written by the justices of Supreme Court of Nigeria complaining about their condition of service. A letter addressed to the CJN. If you are the president of the NBA, how will you respond to the issues arising from their lordship's letter? Thank you.
Thank you, sir. All right, we'd like the both of you to answer. Mr. Taidi, over to you first. We have 1 minute, please, and SAN, please, we have 1 minute as well. Thank you.
My attitude to the issue arising from the letter by their lordships to the CJN, it just draws our attention to the fact that our heads of courts are not accountable with the funds they're entrusted with. I say this boldly because as far back as 2008, when I was secretary of MENA branch of the Nigerian Bar Association, we had this problem. Monies were approved and released to the head of court either for one capital project or the other, but they weren't done. And we came in on an advocacy drive as NBA to try to attract funding to the same judiciary. And we were told by the executive that we had released XYZ amount and we can't see the work done. So we came back to my lord, the then CJ, and we asked him, but you have got upwards of 400 million naira as at then, 2008. And yet, the fence is not there, law reports are not there, and he said we were just rascals coming to show him that we are lawyers and so we want to ask questions and all that. So we took him on and packed ourselves to the National Judicial Council and to start with, within 2 weeks, the fence was built morning, afternoon, night. They built the fence that was not built for 4 years. They had spent the money 4 years ago, they built the fence. So now is the time to ask our heads of courts to open their books. If I have my way, the judge who spends 80% of the time indoors writing rulings and judgments, why does he need a car that costs hundreds of millions of naira to take him to where? So prioritize their medicals and the facilities they need to work with, rather than go and import cars for them, which are contracts, which are avenues to siphon money and all that. So we must be on the neck of our heads of courts, starting from the CJN, to say, open your books, follow due process in your expenditure, so that transparently, if a judge is supposed to get diesel allowance, it is automatically there. But we cannot see their lordships not getting diesel allowance to work at home, while the heads of courts are interested in their own personal things that will benefit them, travels and those other things that will bring them extra income. So we must be on their neck at all times to say, look, let's see the books. What is meant for medical must be spent for medical for their lordships, and so on and so forth.
Thank you very much, sir. Your turn, sir.
Thank you very much. I think I want to confess that I was taken aback when I saw that publication, that letter, which has been flown around, and the story on it. We used to hear intermittently and once in a blue moon of an issue between the bar and the bench. What do we do to have cordiality between the bar and the bench once in a while? But you hardly hear any issue among justices of the Supreme Court, among themselves. If it were to be an issue between the bar and the bench, fine, okay, let us resolve it. But among themselves, and that is the apex court. So it gave one, a serious concern. And I don't think it's something that we can just conclude and say this is what one will do, because such a crisis needs proper interrogation. If I'm the president of the NBA and this happens under my watch, I think what I would do, we have, for example, the Judiciary Committee of the NBA. We have a similar body at the body of SAN, body of Senior Advocates of Nigeria, BOSAN. I will ensure that I lead the leaders of leaders within the profession. We have retired chief justices, retired justices of the Supreme Court, president of the Court of Appeal, and retired justice of the Court of Appeal, who were there before now, and probably such things did not happen. Maybe they happened and they were swept under the carpet, one will not know. Get selected ones and lead them and go and meet the justices and discuss this matter. and see how we can resolve that. So, because it is really disturbing, and one cannot conclude, but I sympathize and also empathize with our justices and judges who are not well paid, who are not well catered for by government. I know there's issue of priority when it comes to projects of the court and the judiciary, but in terms of their take home, they don't have enough. And if we want to discourage corruption, we want to fight impunity among our judicial officers, I think they need to be paid well. So,
Absolutely.
thank you very much.
Thank you very much, sir. In the interest of fairness, it's important that we have a female ask a question here. So please make it as quick as possible. Thank you. And direct your question to one person.
Good evening, everyone. My name is Olubusola Jala. I'm the founder of Strictly Law Business. And my question is this: should either of you become the president of the bar? The RPC, particularly Section 39, is due for review. Law has transcended beyond a profession. We now have the legal services market, and we all know that law is a business. What plans do you have to ensure that the the areas of our RPC that kinds of restrict lawyers from practicing law as a business is reviewed? And what plans do you have specifically for the RPC for a review, in terms of a review? Because my understanding is that the RPC has to be, for the RPC to be reviewed, then there has to be a collaboration between the bar and then members of the bar council. So should either of you become the president of the bar, what plans do we have? And I also want to know, do we actually believe that law is a business? Because you need to believe the law is a business for you to be able to then work towards reviewing that section of our RPC. Thank you. But thank you.
All right.
Economic emancipation, economic empowerment, right? And then revenue generation, whether it's a senior lawyer or young lawyer, because the young lawyer needs the money. The senior lawyer needs the money to pay the young lawyer. And when we talk of young lawyers here, there are some who are on their own already, right? Others are in the employment of others, whichever way, whichever category one belongs to. You need you need good wealth to survive. So, and I give you an example of issue of whether lawyers should sell land or not. That debate is ongoing, because if they sell land, they make more money. What we do now is to do legal documentation and probably receive peanuts as compensation or fees payable to lawyers. So I support we looking at law as business, please. Thank you very much.
Yes, law is a business, and so we must amend the laws to make it fall in line with the so that it has the character of a business. It's not about whether we want to amend the RPC. It's about doing it now. There's no better time than now to do it. If I should have done it yesterday, but since we missed that opportunity, now is the next available opportunity to amend the law. Also, it must fall in line with all the other characters of business. What are the incomes that the lawyers are supposed to earn? This must be protected. In 2007, the internet was not in vogue. Today, that is the in thing. So we must bring the law in tune with the realities of today. That is my take here.
Thank you very much. Thank you very much, sir. Now let's move over to YouTube. We have some questions from YouTube, and I'll take the first question. This is a question that comes up oftentimes when we have gatherings of lawyers. Can we please project the first question? Now, this one is from Abdul Latif, I believe. All right, great. Our first question is from Abdul Latif Fatima. She says, my question is that what does JK Gadzama have for the young lawyers? How can the remuneration of lawyers be improved? And in the same breath, we have a similar question as well. Let's look at the second one. And this second question is also still speaking about remuneration. Yes, it says, okay, yes, what would be done to how no, that's not the one. There are two questions here that talk about remuneration. So basically, Leonard Silk, the question is to you. It's basically talking about what will you do to increase the remuneration and earning potential of lawyers? That's from Onyeka Victor. Thank you.
All right, thank you. Well, you see, oftentimes, especially these days, for many of the senior lawyers who are very busy running from one pillar to the other pillar or post, the young lawyers do a lot of work in the office. They do the research. Most of them are talented. They work around the clock, whether in the office or at home. They're always on the net, busy doing one research and whatever for the chambers, for the sustenance of the law practice and the business. But the question is, do we appreciate them enough? I don't think we do so. Time has come when we must have a conversation on that and see what we can do to set uh, down minimum um, amounts of money, minimum welfare system that we think should be applied to them. I know that the Olumide Akpata regime has done well, particularly on the issue of remuneration, and the remuneration committee set up by him, headed by Mr. Wache, has done some work on that, and it has been adopted for implementation. Now, we will work with that and ensure that the report which has been accepted is implemented so that our lawyers can be well paid and you can see that in them wherever they are, so that they have confidence in the way they do things outside the office and in the public, and they can so that they can match toe to toe with their colleagues anywhere in the world.
All right,
And
thank
and,
you.
and I do that in my office as well. I think I pay reasonably. The young lawyers I have in the office.
Thank you
And
very
that's why
much.
each time we advertise for employment, we have 2,000 to 3,000 applicants who want to work
Wow.
with us.
Thank you very much. We look forward to the day when we can proudly say that the legal profession is one of the highest paid professions in the country. And we have faith that that day will come. Now, the next question is directed to you, Mr. Tidy. It says, how do you plan to work with the bench to ensure better and more speedy dispensation of justice in our courts? Fees charged for a matter that ends up spanning several years loses value over time. This question is from Oludamilola Adejumo.
This question is at the heart of legal practice. Now, while serving as General Secretary, I had four matters which I concluded within a period of less than 2 years. That was possible because the judge was up and doing. So we need to go back to the kind of judges that we have that are presiding over our cases. I say this with all sense of respect and responsibility, that we have not got it right in terms of having the right people man our courts. This is the age, this is the era of ICT. One, if you have a judge today who is not ICT compliant, for me, I advocate that we pay them off, give them all their retirement package and say, go home. Let us bring young, energetic people that have ICT at their fingertips, that can conduct 20, 30 cases in a day without complaining, rather than have some of the old hands that will do 5 cases and say, look, all the other council take dates. Unless we get back to the era of quick dispensation of justice, one, we're losing clients. Two, we're losing income. And rather than come to court now, litigants prefer to go to the police to settle some of their cases. So we must deliberately deal with this matter, having the right kind of people occupy our bench, change our own attitude as lawyers, so that we don't employ delay tactics in the conduct of the cases. And then for a matter that you have charged 1 million naira, you should get that matter off your table in 2 months if possible, so that you can take on other bills. If you keep that file for 5 years, you'll have forgotten by the time you're getting judgment in the matter, the amount of money you collected. And it doesn't do any one of us any good. So we must be very proactive about this to make sure that we deal with the matter frontally.
Thank you very much, sir. Now we've run out of time, but we have to take this question very quickly. It's, for you, Chief Gazama. It says, my question is for Leonard Silk. He says, what are your plans, sir, when elected as the president of the NBA, on sustaining the NBA Security Agencies Relations Committee, which you chair? This question is from Sheriff Hassan. We have a limited time. Thank you, sir.
Let me just make one sentence or two. Now, as God will have it, I submitted a report to the MBA at NEC 2 weeks ago in Ilorin. And one of the recommendations is this: because of the laudable achievements the SAC committee has made over a short period of time, 5-6 months, I suggested that it should be made a standing committee. Standing committee shows its importance. And again, I've been able to recommend that we will have young lawyers across the country constituted into subcommittees, chaired by chairmen of the young lawyer fora in all the branches. So you will find that some branches will have like 5 members, some will have 10, some will have 15, the bigger branches like Lagos. So that it's also a way of empowering the young lawyers. So that together, if there's any issue, say in Abakaliki or in Port Harcourt or in Badagry or in Sokoto, we have men on ground already groomed and ready to work, who can just swing into action and come to the aid of lawyers and people who need such support. So there are many other recommendations, but again, workshop, training for the stakeholders. I think we need to make that uppermost in our minds. There are so many others, but there is no time to keep on listening. Thank you very much.
Thank you
God bless
very much. We'll take thank you. We'll take closing comments now. But before we take closing comments, I want to ask Leonard Silk if you have any question for Mr. Tidy and vice versa, so that you can walk it into your closing remarks.
I don't know. Maybe he wants to start first.
If you have a question for him, then
You
he
have a
can take it
question
in
for
his
me?
final remarks.
Okay. You have a question for me? You don't have? Well, for me, yes.
I want Leonard Silk to go first. Ask your question, because he just finished talking.
Well, I don't really have any question for him, but I have a comment in place of the question. Tidy is a good man. He's very close to me, just like our friend who unavoidably is not here. Where's Mikel? We are all, the trio of us are friends. And my summary of all that I would say regarding the three of us is that we work in good, harmonious relationship as applicants or now aspirants and now candidates haven't been cleared to contest. But the long and short of it is this. While the two of them are eminently qualified to succeed Olumide Akpata, as our president. I am the first among equals, and I am the primus inter pares.
You're making your.
Before I'll make my comments on my closing remarks, my own is a question to Leonard Silk. Now, all over the country, there's a slogan, not too young to rule.
To run.
Yes, the legal profession is supposed to take leadership in that. I am the youngest of the candidates.
As a
So
good
we cannot have those who should be in our advisory committee coming to come and slug it out with me. Simply give him the mandate and say tidy the bar. Now, my closing remarks. Our profession today is at the point where we need a lot of energy, a lot of radical reforms that will bring our income back to us. We're losing a lot of money, and it's not the fault of outsiders, it is our own fault. So you need the kind of leadership that will come and ensure that if the lawyer is entitled to 5% for a transaction, for God's sake, there's no two ways about it. He must get it. Even if it is the lawyers in government who are trying to be a stumbling block, let us all come out and insist that our income comes to us. That is the first welfare package that we can give to ourselves. The man who is able to, and the more you earn, the better you are. So let us have the kind of leadership that has that at the back of our mind to say, let's pursue where our hidden incomes, all of them, let's dig it out so that, for God's sake, we can take back our pride of place in society. Thank you so very much.
Thank you.
By way of closing remarks, I want to say that looking at the MBA inwardly, we need to create job opportunities for our teeming young lawyers who find it difficult to raise income at the Corporate Affairs Commission because of the new law, and quacks who infiltrate into the profession to take what belongs to us, who find it difficult to go to the land registries all over the country in the ministries of lands and survey to gain money that we used to gain during our time, who find it difficult to go to the various police stations to represent clients at their level and make good money. We need to think out of the box and create revenue for our young ones. Now, regarding what my friend said, and which is factual, that I'm slightly older, take my words for that, mark my words, slightly older than Yakubu is not here by 2 years, who is also slightly older than him by 2 years. The sum total of all I'm saying is that we are within the same age bracket. Whether, yes, within the same age bracket. And I don't have a gray hair, and I'm strong and healthy and a sportsman. I play football, I play golf, I swim, I play table tennis, and I'm an all-rounder in most of the sports activities. But above all, experience matters. Your pedigree as a lawyer, whether you have been consistent and committed from day one. I've worked with every past president from what we call the modern bar of MBA, which is from 1998 when Opoko became the president. I worked with each one of them closely, and including Mr. Olumide Akpata. So I am the ripe person for that. I am the square peg in the square hole. And the issues facing Nigeria, you need not just a small person, somebody who has the clout and the cloud and the wherewithal to face all the challenges courageously, fearlessly, somebody who can protect, advance, and defend the integrity and independence of not just the bar, but the judiciary, and fight for rule of law. Thank you.
Thank you very much. I think our panel.
Thank you very much. My final comment is I know that debates of this nature generates a lot of reactions and commentaries. And I want to reiterate that Ellan is non-partisan, And that's one of the reasons why we agreed to this, because we're not taking sides. If there were any questions that were asked that you felt were, because I heard someone say that a question was unfair and vindictive, it was not deliberate. It wasn't Ellan's question. I asked that question and I take responsibility for it. Maybe I got too carried away and thought I was on TV. Those are questions I would ask. But Ellan is non-partisan. Let me reiterate that. It's not their question. I asked that question. So let's give our candidates a round of applause. I think that they really did well. We appreciate your sharing your thoughts and your insights and all the questions that we've asked. And we wish you all the best as the race progresses. Thank you very much for honoring our invitation.
Thank you very much. Once again, can we please put our hands together for our presidential aspirants? Thank you very much for honoring our invitation, gracing us with your time, and answering our questions. And we say, may the best man win. And also, can we please put our hands together for our moderator? She did a great job, Shola Shole. Thank you very much once again for joining us. And in case to our YouTube audience, thank you so much for being a part of this. Thank you for your questions. Unfortunately, we're not able to take all the questions directed at us, but we'd like to urge you to follow Ellan on all social media platforms, on YouTube, Official Ellan, on Instagram, Official Ellan as well, as there'll be more updates and more events to equip lawyers in this regard. Once again, we've had the pleasure of being joined by Chief Joe Kiari Gadzama, OFR, MFR, SAN Live Venture, and the chairman of the NBA Security Agency Relations Committee. We've also been joined by Mr. Jonathan Gunu Taidi, the past General Secretary of the NBA and a bencher. And we've had the honor of having this panel moderated by Shola Shoyele, TV host, and a lawyer extraordinaire. Once again, thank you very much. Joining us on stage, we'd like to welcome a trustee of Ellan, who will be giving us a quick address, and we have something to present to our panelists. Please put your hands together as we welcome Jamiu Akolade.
Thank you. Thank you. Good evening, everyone. I'll make this quick. I know the day is fast spent. I will not stand on existing protocols because what needs to be done very well. I'll say a very big thank you to Leonard Silks in the room, both in the audience and on stage. Leonard Silk, Emeka Ngige SAN, we're very grateful that you've come here. Leonard Silk, JK Gadzama SAN, ever amiable, ever friendly. Thank you very much for coming here. Leonard Senior, Mr. Jonathan Tahidi, thank you very much. I know what your schedule is like. I saw Chief in Port Harcourt and I wondered how he was able to keep up that energy. And of course, Mr. Tahidi flew you in from Port Harcourt just today. In fact, it came straight from the airport to this venue. So we do not take it for granted. The audience who have been with us since morning, those who came in the evening, and the people online who are far more than the people you see in the room, we thank you very much for taking time out of your schedule to attend this event, our first physical event after COVID, and the second Ellan Exchange we've had. This was always a test event. How much do people want to mix together after COVID? And we're very happy it has gone well. And there is no way we could have done all of this without the wonderful support of all our members. And please, you will especially please give an applause to the tens of dozens of members of the Employment and Labor Lawyers Association. This is almost entirely put together and funded by them. And all our sponsors that you see on the screen, IHS, Coca-Cola, Petstone and Grace, and you see all these law firms, members, outsiders, and it's just beautiful how much we can achieve collaborating together. My beautiful colleagues at the bar who've been with us, Shola Shoyele, moderated the first NBA presidential debate that was fully virtual we did 2 years ago. That brought in Mr. Apata, and she's here with us. First class TV presenter. She doesn't charge us a dime. In fact, I'll tell you a joke, and we tried to get another presenter to join her on stage. And when the man mentioned his fees, they just had to say, Shola, we are left with you. So
this is to say special thanks to Shola that we do not take you for granted. Now we know the value of what we are getting for free, and you only do this out of love for us. So follow us on our social media everywhere, like we've said, and we will continue to deepen the conversation, like we said in the ad promoting this event. And on behalf of the trustees, we are two, and the members of Ellan, we have a small token as a show of appreciation to our learned seniors who have come to grace this occasion. On behalf of Ellan, Chief, I present this to you as a token. We are very grateful to have come and wish you all the best in this adventure. It is what it is. Thank you very much. I hadn't met you before now in person, but I'm so glad that we called you and you came with us. I wish you the best.
Thank you so much.
Yeah. Thank you very much. And just take a group picture, and then I guess we can call it a day. If Ellan members in the room want to join us, they're free. You're also one of us. Thank you very much, everyone, and have a good evening. Thank you. Thank you very much.
Okay, let me, you have your card. Okay. Or you send me.
I will send you a message. Yes.
Okay.
I'll send it to you.
God bless you. Thank you very much. Yeah, this is my.
We had so much people in the morning, but after they left in the
I saw them.
afternoon,
Yeah,
somehow they just couldn't come. But there are a lot of people online.
online.
That's
Yeah.
what I noticed.
The pleasure.
Thank you. I wish you the very best.
Thank you very
All the
much.
best. The
Okay.
very best.
Thank you very much. I think this is an opportunity. I was trying to ask, how do people fund it? I thought, I mean, how do you fund
You
it?
see all the names here.
all the
You see all the names, the firms,
Lawyers.
oral practice,
Because
small,
this
small.
is to our advantage. I mean, I was just asking. Maybe after the election, next time we can remember there's nothing at stake.
Exactly.
Yeah, maybe.
I hope you get
Now
there.
that we're contesting, but thereafter, one can find a way to support.
We started with Olumide Akpata. I mean, all of them are
Well,
participating.
at a
During
point.
COVID.
No, I mean,
No,
as-
this